Yes, Mr. Speck.
Can I turn to look at what the judge did in terms of valuation? And this is going to take quite a while to work through, I'm afraid. On a couple of occasions, I will have to take my lords and my lady into the draft judgment, as we did in the Court of Appeal, to make sense of how we got where we did. But that's some way down the line. Before I actually get into the detail, I think you would have picked up that what we got from the judge in terms of valuation methodology bore no resemblance to the methodologies and issues the parties had been canvassing at trial, and which had been subject to their expert evidence. He rejected all of that expert evidence, and we'll look at how that was done in a minute, and what he did in terms of his unheralded approach. But can I make two further points of introduction? First, it's not just as to the valuation where the judge went seriously off-piste, as it were. There are two other key areas to note. One was he threw out the entirety of a very largely agreed licence text. The point of the whole exercise is obviously to settle a licence that can be executed and will be a proper, complete agreement. And you won't be surprised to hear that we've agreed nearly all of it, as has occurred in other cases. However, in this case, he just threw that out too.
Is that an issue before us, though?
It's not an issue. It's just what I want to explain to my lords and my lady as to what he did was so far away from what the parties were doing. It's just something that my lords and my lady should have in mind. You get it described in the beginning of Lord Justice Arnold's decision, where he also explains that my friend agreed that the agreed text could come back without formally accepting that he'd gone wrong. The second area where he went seriously off-piste was a decision that my learned friends already referred to this morning as to the decision as to the payment for past sales. The dispute between the parties is basically the dispute that you've had outlined to you today, where I think actually the difference between us is about 7 weeks, but whether it's 6 years back from the claim form or the beginning of 2013, and the judge made a completely different decision, which wasn't what either party was contending for, and in fact nobody's contending for before my lords and my lady. So those were two other areas where he seriously departed from the scope of the debate that was before him. The other introductory point I want to make is that the judge's completely new approach in this judgment that we're just about to look at resulted in an absolutely massive exercise in correction. The correction document the parties had to put together is like certainly nothing I've ever seen before. And it was due in large part to two things. The first is the judge was creating a completely new methodology and doing his own often quite complicated calculations as he went along. And regrettably, he got quite a bit of it catastrophically wrong, just in terms of the sums. And the second thing is there are aspects, sometimes pretty fundamental, that he just completely misunderstood.
Well, you would have thought you would have been sensible to have sent it to the parties before the judgment rather than give them a chance to comment at that stage, but there we are.
Well, one of my submissions is going to be that you don't do this kind of exercise departing from the scope of the debate that's been had before you without giving the parties and the experts an opportunity to have a say about the propriety of what you're doing. Both kinds of trouble are littered throughout that document. And just for your note, the correction document is a jointly prepared document by the parties. It's about 40 pages long. It's at pages 1975 to 2014, and it is a quite extraordinary document in my submission.
Were the corrections agreed?
Well,
on the assumption the judge's methodology was not going to be interfered with.
Yes, some of them were, some of them not, and it's one of those documents where you've got different colours for things that people said. So it's not the whole thing was agreed, but some were.
So what was the page reference?
1975.
19, I read.
1975,
yeah,
all the way through to 2014. So can we actually turn to the judgment then, please? And I want to begin with the judge rejecting the entirety of the expert evidence on both sides. So that's page 508 and it's paragraph 311. It's within a section that Lord Justice Burse himself described as important in his paragraph 35. And the judge says he's derived no benefit from the work of either valuation expert, and he rejects their evidence as unhelpful in resolving the FRAND question. It's everything they did, no benefit from anything they carried out, and a striking thing about this passage of the judgment, it's most definitely not an exercise in comparing the strengths and weaknesses of the expert's approach, and in particular the significant aspects of it that were common ground, and comparing, the minor significance of the differences between them, and comparing that against anything else that he's going to do. And this is the point that I've just made to my Lord Legate really comes in. Rejecting the totality of the parties' evidence and approach, an awful lot of it, which was common ground, really did require a proper opportunity for us to be heard and to consider the analysis that he was putting forward. Anyway, the reasons for his rejection start in paragraph 312, and he states that the nature of the comparables in the case has taken the experts far outside the zone of their proper expertise. And he goes on that both experts would have approached a typical valuation exercise with competence and skill. And he means the kind of thing he described in 295. We don't need to look at it, but for your note, that's the domestic property valuation, looking at factors such as freehold, leasehold, and so on. At 313, he refers to his earlier expressed view as to the Optis and Apple comparables being categorically different. And just so you understand that, again, we don't need to look at it, but for your note, it's a reference back to paragraphs 292 to 294, where the essence of the point that he's making is that Optis comparables are all for a licence to the Optis portfolio, a series of values for one thing, i.e. the portfolio in issue, but Apple comparables are where Apple is the common factor, so different portfolios, different counterparties. Now, paragraph 13 continues with criticism of the experts for not seeking to understand differences underlying what that taught. He says that was a surmountable difficulty, but which neither party's expert made any effort to surmount. We have to say we're not at all sure what the experts might have had in their reports, but it's something he criticises them for anyway. If we go over the page on 314, the judge moves to what he says is an insurmountable difficulty. So this is his real issue. And he says how to resolve, so dealing with, what he calls the three subjectivities. And that's the insurmountable difficulty. And just to identify those for my lords and my lady, this is referring to three topics identified earlier under the heading the subjectivities. So if you go back to 301, paragraph 301 on 505, down at the bottom you see the subjectivities, and there are three things here. What the judge calls first different rates, the heading just above 303, and that's the point that royalties payable under licences may be expressed as a lump sum, ad valorem, or per unit rate, what we've been calling DPU. And just note while we're there, he specifically refers to these are ways which royalties can be computed. Do you see that in the second line of 303? And it's clear that the judge has in mind that ad valorem and DPU, which he's calling per unit here, are somehow deficient because one does not know the totality of the money payable. What he labels what's the licence actually worth. You only know that when you know the sales volumes. And we see he refers to that point both in subparas little 2 and little 3. I think about 3 lines into both of them. And we also see here an instance of something we see elsewhere. He often refers to a lump sum payment with the word rate tacked on, reflecting his misunderstanding that a lump sum was itself an approach to valuation rather than a payment mechanism. You see it, for example, 3 lines up from the end of subpara little 3. So that's the first subjectivity. The second is the issue of cross-licensing at 305. And he notes there's no such complication with the Optis comparables, because there's no cross-license in them. And he says it is a point on the Apple comparables. Paragraph 306 refers to those licenses producing a net rate to be paid and which do not attribute a specific value to the Apple portfolio. And I pause to just note, it appears to be using the word rate in a very unusual way again. There's certainly a net amount to be paid because a lump sum payment structure has been adopted, what you might call a net payment, as he describes it in the final line of this paragraph. 307, we see the final subjectivity, future royalties and past releases, specifically that licenses often are in respect of both, but don't differentiate between the past and the future. He says, providing for a single rate. And my submission here is that the use of the word rate really is becoming problematic here because it makes it sound as if the licence provides for a single rate in the sense of one unit price for sales, whether it be a DPU or ad valorem, for both past and future. But that's simply not the characteristic that the judge is seeking to address here, which is that there's a single payment, a lump sum which covers future and unlicensed past sales, if and to the extent that they exist. And it's not in any normal sense a single rate for future and past sales. Now, before I move back to where we were in paragraph 3.1...
Sorry, I just want to be sure I've understood. There is a single rate for future sales, but are you saying that it's different from the rate for past sales?
No, he seems to be suggesting that there's a single rate applying to both, but what he's considering is that this is a lump sum, so there's just an amount of money paid. There isn't a rate in any normal sense of the word.
You say it's because he calls a lump sum a rate.
Yeah, it's because he's calling lump sum a rate again and again.
Well, it may anticipate, that he's extracting a rate from these lump sums and then saying that it's unreliable because you don't know how much past is built into it and how much is future.
But perhaps. What it does, it's all part and parcel of his idea that lump sums are a way of valuing. And we'll see that it was common ground that it's not, but he rejects that. But
if you have a lump sum, you've got to divide it up, presumably per phone, based on anticipated future sales and estimated past sales.
Absolutely.
And isn't that what the judge is saying?
He's talking about that. I'm just drawing attention to the fact that he keeps using the rate in a way which is very unusual, and it's rather part and parcel of his belief that it's a way of computing the value. He's addressing the point that my Lord just put to me, definitely.
Thank you.
Now, before we move back to where we are in paragraph 314, can I pause and make the following points about these insurmountable subjectivities? When he says there are three rates, stating that there are these three different types, it's the point I've just been alluding to. It's a manifestation of him getting into a muddle over valuation approaches, how one may compute what's to be paid, the valuation approach, and then the payment structure that you may adopt. And this muddle permeates the whole thing and has echoes in earlier bits of the judgment. Can I just take you back to page 375 to 376? This is paragraph 55, little 2b. So right at the foot of 375, subparagraph B, where he states Apple was contending for a lump sum, but that it was not saying that an ad valorem rate be used and simply converted into a lump sum. And he goes on and says in a sentence added after the parties' proposed corrections, that nor was Apple suggesting a similar approach utilising a per unit rate. So he's saying that Apple's case was not the licence should be a lump sum having been arrived at by either ad valorem or per unit. And my lords and my lady will see the footnote 59, where he remarks that Apple suggested that its approach was to take a per unit royalty, i.e. DPU, and use predicted sales volumes to arrive at a lump sum. The footnote ends with a dismissal of Apple's comment to the effect that the uncontested evidence was that Apple's approach was to calculate a per unit royalty and then use predicted sales over the term to arrive at the lump sum. And he dismisses that as not a description of the evidence that he recognises. And it's perhaps an even more clear instance of the judge just fundamentally misunderstanding what the evidence before him was doing. Lump sums were never treated as an approach to valuation as such by any expert, nor was it Apple's case. We agree with Apple's point submitted to the judge that their approach was as they described, and we said so at the time. But despite the fact that we were both agreeing in drawing this really rather fundamental or basic error to his attention, he stuck to his guns. And what the judge's rejection of the agreed correction shows, and what's reflected again in the different rates section of the subjectivities section, back of paragraph 303, is a very fundamental failure on the part of the judge to appreciate even the basics of the expert's approaches and the parties' cases. And it's something that certainly on our side of the court left us feeling very uncomfortable and frankly a real worry as to how we managed to conduct a 5-week trial, and the judge hadn't understood even that, and perhaps even other basic aspects of the case being canvassed. Even when we were in agreement trying to correct it, he said we were wrong. And we see the same point reflected in the passage where the judge is giving his reasons for rejecting the experts that we were looking at. I'm referring back to the section we were in, particularly footnote 438 on page 509. Footnote 438 on 509 refers to the lump sum approach to FRAND, which he says, as advocated for by Apple. It just wasn't. Time just doesn't allow me to pick up every instance of this fundamental muddle, but for your note, it's basically the same thing that Lord Justice Burse identifies in his paragraph 29, specifically in relation to the non-sequitur in the judge's paragraph 211 and the cross-examination set out there. So I say that about the first subjectivity. As for the second of the judge's subjectivities, cross-licensing, this is something we will see the judge has to deal with, as he adopted mainly Apple licenses. So there is a real difficulty in my submission with saying that having to deal with this is a feature of the expert's approach that is an unsurmountable subjectivity. One of the 3 key features that drove the judge to reject the expert evidence as a whole and unhelpful, when in fact he has to deal with it. And in fact, when we get to it, we'll see that he deals with it in a completely unsatisfactory way, basically ignores the relative level of sales and calculates what he calls a net stack share. But he's rejecting the experts and their approach because unpacking has to accommodate this insurmountable difficulty. But he had to too. And for your note, you will see that point made rightly in my submission in Lord Justice Burse's paragraph 96. A similar point can be made about the third subjectivity, the past and future sales point. When we get to it, we'll see the judge had to address this point too. And again, he did it in a completely unsatisfactory way. But at this stage, the point I make is the same. He's saying having to deal with it is an insurmountable problem, and so a reason to dismiss the expert's approach. It shows you he hasn't understood he will also inevitably deal with it. Can I take you back, please, to para 314 on page 509 and the further criticisms of the experts in those sub-paragraphs? The essence of these are they were not sufficiently independent, were restrained by their instructions. These are points that were never put to them, as Lord Justice Burse notes in his paragraph 88. And for your note, it rather goes hand in hand with the statement further in the judge's judgment in para 315 on page 512 that they provided no independent judgment. Can we look at the detail of the criticisms on page 509? So for Mr. Bazant, it's para 314(1). The judge says he was instructed as to the way he should approach valuation. Firstly, that he was instructed to consider a comparables approach only. And you see the footnote 435 refers to the statement in his first report as to his instructions to apply the comparables approach for the purpose of that report. And as Lord Justice Burse explains in his para 92, that's no criticism. Cimetidine is an appropriate approach in law, something that my friend now accepts, as I understand his printed case. And I would add at this point in time, my lords and my lady, because of the very unusual pre-trial procedure the judge had adopted, of basically directing the parties that pleadings would be completely replaced by position statements of their positive cases served together with the evidence in chief, what else was he supposed to do? At that point, we didn't know what Apple's evidence and position statement would say. And thereafter, Mr. Besant certainly did engage with Ms. Guttridge's evidence and approach. As you may imagine, there were several rounds of expert reports. The next criticism in this subpara is that he was instructed which licences to look at. It appears from footnote 436, the criticism is that he's looking at this point in time only at the Optis licences Optis relied upon. And again, as Lord Justice Burse correctly states in his paragraph 92, expert accountants might well need to be instructed as to which licences to consider. And again, we didn't yet have Apple's case and its analysis of its own licences. What else was he supposed to do? He certainly did engage in those reply reports. Moreover, can I just pause and draw attention to the fact that earlier in the judgment, as regards which Optis licences Mr. Besant covered in his evidence, there is in fact precisely the opposite view expressed. We needn't turn it up, but for your note on page 478, at para 236, the judge is critical of the fact that Mr. Besant did not stick to the Optis licences that Optis pleaded reliance upon, and reviewed all of the Optis licences, including the 4 or 5 not relied upon it. Yet by paragraph 314, the criticism seems to be the opposite. The third criticism in paragraph 314, little 1, on page 509, is, I'm afraid, yet another manifestation of the judge simply not understanding the fundamentals, that a lump sum was a payment structure, not a method of calculating royalties. What the judge says is that Mr. Besant unpacked lump sum royalties into ad valorem, and then he says this.
Sorry, where are you now?
I'm the third reason in 314 little 1.
314?
Yeah, the numbers are sorry, the
Thirdly.
reasons. Yes, exactly.
Yeah.
First, second, third. So I'm on the third one. So top half of 509. Have you not got it, my lord?
For some reason, sorry. I'll get there.
509.
1 and 2.
3.
Then we
It's
go
in
into a
one.
whole lot of
No, it's in
crossing.
1.
Oh, I'm so sorry.
They're all in one, sorry.
Yeah, all right.
They're all, the reasons are identified by saying firstly, secondly, and so
Yeah.
on. But it's all in that paragraph,
Yeah.
sorry. So thirdly is that Mr. Besant unpacked lump sum royalties into ad valorem, and then he says this without doing the reverse, i.e. converting ad valorem royalties into lump sum royalties. Totally confused in my submission. What would it even mean to take, for example, a licence with ad valorem and unpack it into a lump sum royalty?
Does he mean DPUs?
No. He means put it into a lump sum.
You start with a lump sum, break it down, and then put it back into a lump sum.
No, I think he's talking about the lumps. The ad valorems weren't changed into lump sums. What my lords and my lady need to have in mind is that there were, across the whole group of licences, some of them were ad valorem, some of them were lump sum.
And some are DPUs.
No, I don't think any were in fact DPUs. Was one? I'm told you're not real right. One was. But
his complaint is that where there was a lump sum, that was converted into ad valorem, but not the reverse, he's
where there was
saying.
an ad valorem, we didn't do the opposite. That's the complaint.
Oh, I see.
Yeah, that's the complaint.
And that presumably is because nobody was contending for lump sum as a specific basis of valuation.
Exactly, but we'll read on. Read on. my Lord's absolutely right. What would it even mean to do that? But more unfairly, he goes on and says, he infers that even though Mr. Besant doesn't say he was instructed to approach the issue of unpacking this way, that must have been the case. That is extraordinary. Nobody's ever turned their mind to the idea that some lump sum approach to valuation, which might call for an AV or DPU express license to be unpacked into a lump sum. And even more extraordinary is the following text. The judge says it must be the case that Mr. Besant was instructed not to unpack ad valorem rates to a lump sum royalty, because he, i.e. the judge, is going to explain later that it's a key factor in answering the FRAND question. The obvious implication is that not only is it a key factor, but it's something. The silent premise is that Mr. Besant would obviously have known that. Would have known that unpacking ad valorems to a lump sum was a key factor in answering FRAND, and he must have been told by the legal team as a matter of instruction not to do it. The subparagraph ends by saying that ad valorem approach as opposed to lump sum must be justified, not followed or assumed, and that's where we see the footnote that I've already taken my lords and my lady to. So this is another rather stark example of the judge completely missing the real dispute, which was between DPU and ad valorem unit pricing, which Mr. Besant did address by unpacking into both. And regrettably, it's another passage showing how little the judge understood as to the fundamentals of the evidence and the argument before him. Again, my lords and my lady, Lord Justice Burst dealt with this point. For your note, it's in his paragraph 93, where he explains that this part of the judgment misunderstands the purpose of unpacking and the distinction between a lump sum and a per unit rate. There is absolutely nothing in any of these points that will come close to justifying rejecting everything Mr. Besant did in his evidence as unhelpful.
Or indeed Miss Guttridge.
Indeed, I'm going to come to her, because that's absolutely my submission. He should not have rejected either of them. Criticisms of Miss Guttridge are in the next subparagraph. This is subparagraph 2 on page 509. And the point the judge is dealing with here is a criticism made of her approach in approaching the issue as if it was a special licence and price for Apple. And the passage of the transcript set out, it's fairly long, but that's the essence of it. It was a criticism of her approach that we made, but it's not something that means nothing whatever in her evidence is of any relevance or use. Certainly not that all her unpacking is useless and that she exercised no independent judgment. That was no part of my case. I was criticising her for that one specific point. And do please make a mental note here, because it's not without considerable irony that this aspect of Miss Guttridge's approach that the judge is relying upon here, special price for Apple, actually ends up being part of his own approach. Anyway, the judge rounds it off at paragraph 311, page 512, by repeating his view that the direction of travel of the experts' reports was set down by the parties who instructed them. And again says all they did was follow that and unpack in accordance with their principles respectively.
That's 315, isn't it?
Yeah.
Yeah, sorry, what did I say?
311.
I do apologise. 315, you're right.
And 316 must be read as well.
Yeah. And it's really not a fair criticism of either expert's unpacking of the licences. And over the page at 317, we see yet another instance of the judge muddling up lump sum as a method of calculating royalties, where he again wrongly asserts Apple's case was for lump sum royalties as the contrast to Optis's AV preference. It's another example that Lord Justice Burst drew attention to. He describes it as another instance of the judge's confusion between a DPU, Apple's royalty case, and the lump sum mode of payment. And for your note, I don't ask you to turn it up, That deals with that in paragraph 41 of the judgment in the Court of Appeal. So that's the judge rejecting all the expert's work and evidence and the reasons he gave, which I regret to have to say betrays a pretty fundamental misunderstanding, which also caused him to make unfair and unfounded criticisms of both experts. And I've picked up the key aspects of Lord Justice Burse's judgment addressing this as I've gone along. But it was ground 4 in the Court of Appeal, so specifically addressed between 86 and 97, which substantially endorses the points I've made. Now, before we move on, can I point out that this section that we've been looking at is in fact the section where the judge deals with what he considers to be the problems with the comparables in extracting information. It's section K3, the whole section, from para 288 to 319. And my friend referred to the judge expressing his view as to the limitations on extracting usable information from the comparables. And he then told you there was evidence at trial about things like non-cellular SEPs, and I think yesterday he added wider business relationships too. And the point I made earlier, my lords and my lady are being encouraged to consider what my friend is telling you, that the points the judge referred to and relied upon were the ones that he identified. But section K3 has nothing to do with anything like that. It doesn't do what my friend is suggesting. The subjects addressed, just so you have them, are the exclusionary approach, so that's whether you should be picking the best or including them all. That's paragraphs 290 to 291. The categorically different point that I mentioned earlier, that's 292 to 294, so that's the fact that one's a group of licenses all to the Optis portfolio, the other is various portfolios where Apple's the licensee. The unpacking requirements, specifically the subjectivities we've been over, that's para 295 to 307 as a whole, which then lead to the section on the experts being rejected from 308 to 317. And the last bit in this section is 318 to 319, which refers to 3 points. First, the Apple holdout issue, and second and third are in fact variants of the allegation about agreements being used in future negotiations. One subparagraph is specific to Optis and the other is general. None of it is to do with non-SEPs being included or business relationships. Can I move on to the judge articulating...
Just before you leave 317, he seems to, in his own argot, as it were, be using lump sum as a summary of Apple's case,
Yeah.
which you say was not Apple's case.
So does Apple.
Yes.
We all say that wasn't Apple's case. We all agreed that, however, whatever happened at the end, we didn't want an agreement with running royalties being paid with the accounts and auditing and payments having been made every quarter or whatever. We all agreed that there would be a lump sum in the licence as the payment structure, and we argued about the unit pricing, whether it should be DE or AV at trial, but nobody ever approached valuation as something that could be done on a lump sum basis. So this is just another example of the thing that I showed my lords and my lady in the footnote to paragraph 52 and 2, where he basically rejects what both sides had said, in fact, about Apple's case. So can we move to the judge articulating his own approach to the FRAND valuation? That's from para 453 on page 582 onwards. And was
there evidence about sales projections, or was that an aspect of it? Do you know how you were going to arrive at a final figure, or how many units were going to be sold?
We'll come to that, and then actually what we'll come to is the way in which it was used by the experts. There was a difference between them as to the analysts' data that they used to do that. And one of the points that I'm going to be showing you, probably not till tomorrow, is that even though there was a difference as to how you did that, where you went for the source, it made no difference to the unpacking. So much so that my friend said in his closing that the judge needn't form a view on it. It made absolutely no difference. But there was evidence as to how the experts did it, and they happened to have gone to different sources. And I can't remember off the top of my head now whether or not there might have been a fight about how it would be packed up in the licence being settled. But it was a dispute about figures that were pretty close anyway.
Right.
So can we move on to the judge articulating his own approach to the FRAND valuation? That's from para 453 on page 582 onwards. And we see the heading, an articulation of an approach, which rather highlights it being proposed and set out for the very first time here. This was completely new, quite a shock when the draft judgment first landed in our inboxes. 453 says his objective is to articulate the appropriate price that an implementer should pay to a SEP owner holding a proportion of the stack. And that price must be FRAND in that it's fair, reasonable and non-discriminatory. And we see, he says, that both as between SEP owners, who, quotes, co-own the stack, and implementers who wish to purchase access to it. What the judge is basically saying is he's going to assess the price of the whole stack and thereby derive the price that a SEP owner holding a proportion should be paid.
But he has to do that if he's rejecting the Optis as comparables, the Optis licenses as comparables. Does he not? He has to do something.
He has to do something, but he definitely doesn't have to do this kind of lump sum approach.
I understand. This you say wasn't foreshadowed by the experts,
Not at all.
nor in argument.
No, not at all. Not at all.
Yeah.
And what they do say is the last sentence here seems unobjectable enough by saying it must be fair, reasonable, and non-discriminatory, at least as regards stating it must be so as between implementers. You might think that the price different implementers pay should be about the same. But then if you look at the very next paragraph, 454, the judge says that more specifically he's pricing the value to Apple of the portfolio. And that's rather a peculiar thing to say if it's broadly the same for everyone. And of course it's the point that I asked you to make a mental note of a few minutes ago. That was the specific point we were criticising Miss Guttridge about, and he was relying upon, but now he's saying he's going to do it. .455 says the only material the judge has to ascertain this price, it's the price to Apple of the portfolio, is the Optis and Apple comparables. And he refers to the concern he's expressed about them, but says it's the best evidence that he has, so he must do the best he can. There is a peculiarity there. He's expressed his concern about the comparables earlier, rejected an ordinary comparables approach. And at this point in his judgment, at that point in his judgment where he wasn't worried about the alternative, now he's putting forward his alternative and saying, well, the best evidence is the comparables. Now, paragraph 455 goes on and says he's not going to allow the exercise to fail for want of data. He's going to apply assumptions where necessary and broad brush or broad axe. And as to this, I will seek to identify the effect of what he does, often without even appearing to realise it, and explain how what he's doing is worse significantly to that which the experts did. And we see that what he will do generally is described at 456. He'll price the entire stack to Apple. Again, the focus is on Apple's specific price, and then apportion pro rata amongst what he calls the co-owners in proportion to their holding, which he's going to do by inography.
Well, that's because he's got the Apple licenses as his data, isn't it? He has to do that.
Well, he's got them, but he's also got the Optis licenses.
I know, but he's regarded those as useless.
Not yet.
No.
Well, all right, but he does conclude that.
He does conclude, well, all but one,
Yeah.
but not yet. but at the moment, he's got them all.
I mean, the whole problem in this case is that the comparables, whatever you care to call them, are not very comparable, and they're pretty useless data, but if you don't use them, you've got nothing to go on. So it's an almost impossible exercise, other than just by coming up with some sort of subjective numbers at the end of the day.
Well, my submission is going to be that you don't do this, certainly not without telling us, and what the Court of Appeal did is a legitimate way to use the best of the comparables which you may conclude are not as good as they've been in other cases. And as I said to my lord and my lady before, the shorter German, how those comparables were used is crucial. They weren't used as close parallels in the sense that they're meant to be giving you the price. They're a way of identifying a window, i.e. cutting out what isn't FRAND. Anyway, back to the judgment, if we may. Paragraph 457 says, in broad terms, he's following the Apple framework, although that he's jettisoned key elements of it as unhelpful and wrong. And over the page he says, it's an obvious cause and form part of the Optis top-down cross-check and would have occurred to him in any event. Just to be clear, my lords and my lady, what the top-down cross-check and the Apple framework have in common is that they utilise the notion of an overall stack price, but they don't value it in the way that remotely resembles what the judge did. That is the extent to which what the judge does resembles the Apple framework and our top-down cross-check. Now, the section starting at para 459 on page 583 is where he looks at identifying the stack and the shares in the stack. And the first three subparas of 460 deal with the stack shares of Optis, Apple, and the Apple licensed counterparties, respectively. 460(1) uses 26,600 as the total stack size, so the denominator, when he's calculating the Optis share. And so he gives numbers there of 0.51 and 0.31 with the Ericsson patents excluded. This subpara notes that in some Optis comparables, not the entire portfolio is licensed. And that's a reference to the fact that in some agreements only a part of it was licensed. But he says he doesn't propose to reduce it for that point. And it's a point he refers to again in subpara 3, just above the table where he says he doesn't need to calculate share for Optis counterparties. That's because there's no cross-license. He goes on to say that he will use a single figure for Optis, which he suggests is generous to Optis. So he's not going to use a different figure when only a part of the license, part of the portfolio was licensed. And just pausing there, he's got into another muddle on this. The generosity of this point, treating the sum payable as being for the whole Optis portfolio, even if the license was for a fraction, would be generous to Apple, not Optis. If a given price was being paid for a fraction, obviously a higher price would be paid for the whole. My criticism is not so much that he's decided to do something, it's that he's got no proper understanding of what's actually going on in his new method. And I also do draw attention to the fact that when it gets to dealing with a light point in the part of the process when it would be generous to Optis, so when deciding whether to make a discount for the fact that part of the Optis portfolio became licensed after trial, the Ericsson patents, he does the opposite, and he does make a reduction.
Sorry, can I just stop? To be absolutely clear in my mind, please, what the judge is doing. He's taking 0.31%, excluding Ericsson, as being the share held by Optis of the stack licensed to Apple.
Yes. And he's also taking 0.61 as the total size of the Optis portfolio. And he's saying...
It's the total of the Optis portfolio licensed to Apple.
No, I thought of the whole...
Right.
It's the whole stack, isn't it?
No, the whole portfolio, not the whole stack.
Oh, right. Oh, sorry.
No, maybe I'll pause and just... There was a point that arose because some of these Ericsson patents became licensed independently through Ericsson after the trial.
Right.
So the reason we've got two numbers here is because of that. What he's doing is he's saying this is the number for the Optis portfolio, 0.61.
Yeah.
Even though some of these agreements have only been in respect of part of the portfolio, he's not going to reduce it. So he's going to treat it as being for the 0.61% in the cases, even when it was only a part.
So 0.61 you said?
5.
0.51 I think.
Sorry, 0.51. Yeah.
5-1, yeah.
That higher number, he's going to treat it as being attributable to a license for the whole,
Yeah.
even though it wasn't.
I understand.
Yeah.
He just hasn't understood that at the point of extracting price information from licenses, this assumption is not generous to Optis at all.
No.
Now, in paragraph 416(2), he takes Miss Guttridge's assessment of Apple's share, 1.07%. And just so you understand, that is not using the 26,600 denominator, because it wasn't her denominator. So he takes a number, but he isn't using the same denominator. And paragraph 460(3) is a table identifying 19 Apple licenses, giving the share of the stack for each counterparty. These numbers are also taken from Miss Guttridge, so they don't use the denominator the judge chose either.
I think somewhere he says he
He's going to change
he got wrong what Miss Guttridge number took anyway, isn't he?
He's going to change it in a minute to a different number again, but this is where he's done at this stage. And you'll see that some of them are very significant. Huawei's about 8.5%, Ericsson about half that, Nokia's significant, Qualcomm not that far behind. But many are really tiny. For example, the second entry, Grand Mesa, is 0.005%, 100 times smaller than Optis. And it would be even smaller if the same denominator, 26,600, had been used. Orange, Longthorn, KPN are all tiny too. Straight away, the judge says he's not going to use the 26,600, so I'm at subpara 4 on 584, but 22,000, which is not Miss Guttridge's denominator either. You can see what that is in just a little bit less. And he recalculates for Optis the share, and that's where he gets 0.61 and 0.38, which excluding the Ericsson families, which is those are the numbers that we've been using.
Is that just an assumption that it must have been less some time ago because it gets larger as time goes on? Is that what basically what he's doing now?
It is to do with change over time. Mm. So that's the stack share measure when using enography as the basis.
Are those figures quarrelled with? Those in little c?
Not now. I'm just showing you how he got there and what he did. As my lords and my lady understand, at trial we were trying to advance the case based on a different way to assess stack share, PA consulting. By the time we got to the Court of Appeal, we accepted to use enography. It's one of what Lord Justice Burr said was a helpful concession.
Thank you.
The next topic is the value for the stack from para 462 on page 585. And para 462 says he can't actually value the entire stack. But what he can do is consider as many components of the stack as he can, rendering them comparable or equivalent, and use those equivalent values to derive a 100% value to attribute to the stack. And the latter half of that statement, what he can do is use the components of the stack as many as he can. Apple refer to in paragraph 25 of their case, rather suggesting it relates to the matters they've identified in their lengthy paragraph 24. And that's an unhappy juxtaposition, because it's nothing whatever to do with those points, nor anything at all other than what he's saying here, in that he doesn't have everything in the stack, but he can take what he's got. He's basically saying he wants to include as many components of the stack as he can, which in practice means the Optis component from the Optis licenses. In fact, we'll see he uses just one, as you already know, and components from the stack from counterparties to Apple.
Yes.
And as to that, can I just pause? In the light of the submission made yesterday as to Google being concluded as an oversight, my lords and my lady might want to note this paragraph because it's obviously not an oversight, and there are several other instances where he makes it absolutely plain that he's well aware of what he's doing. And the last sentence of 462 is worth noting because there he says using multiple data sources, that obviously means multiple agreements, mean outliers or unrepresented cases can be averaged out and a safer, more reliable overall figure obtained. And that's the normal distribution assumption point that we covered this morning. Paragraph 463 at the foot of 585 begins by stating that the stack can be valued either as a total ad valorem rate or a total lump sum rate.
Does he by lump sum rate mean really lump sum based on DPU?
No, he means lump sums. I'll show you what he does. He really does. And the DPU's just been forgotten now. And he says that reflects the comparables that were available to him. And that seems to be a reference to the fact that the comparables, at least broadly, were in the form expressed either as an AV or lump sum. As I was told earlier, I think it might be that one is a DPU now, but he's broadly considering them to be AV or lump sums. And he's going to do both. Very clearly thinking lump sums are a route to valuation and completely missing the true alternative to AV, that of DPU. Paragraph 464 over the page says the lump sum price for the stack is a total price payable for use of the cellular standard, irrespective of ASP, that's average selling price, and volume sold by Apple. And he says that's mainly achieved through Apple comparables. And the word mainly is important because it isn't wholly. And the reason in the second sentence, he goes on to state that Optis comparables cannot be used because the unpacking introduces too many subjectivities. And he seems to have in mind this converting AV to lump sum as a process of unpacking again.
But didn't he in 463 say the Optis comparables didn't need unpacking?
Yes, I think he's got that round the wrong way, actually.
Right.
Yeah.
Okay.
And every time you read that, even when he talks about the Optis comparables having to have something done to them or not because they're AV, it's obvious he always means not including Google because that's a lump sum. Anyway, it seems he has in mind converting AV to lump sum as a process of unpacking again, which, as I say, wouldn't apply to Google. And he goes on to say the lump sum must be calculated by reference to the implementer, a portfolio which the Optis comparables don't do. And my lords and my ladies see the additional points made in the footnote 599. He says the Optis counterparties, with the exception of Google, are far smaller than Apple, so would pay a lower sum in any rational market. So he's basically saying the exception of Google, all the other licenses, if put in terms of a lump sum, would be for an implementer who has far smaller sales, and in a rational market they should be paying less. And if we just pause, there's a peculiarity of what he's doing. On the one hand, you see the first sentence of paragraph 464, he's adopting an approach which assesses value, which expressly doesn't depend upon volumes. But at the same time, he's saying in a rational market, the lump sum payable for smaller participants would be lower because of this point, except for Google. So it seems as if the effect of what he's saying is that all those lower levels of units would pay lower lump sums but from Google up, or perhaps more accurately, some position between those lower ones and Google. But anyway, at some point you get to a position at or below Google. And above that, everyone pays the same, regardless of volumes. And that's completely insupportable. And in fact, there's much more detail to this, because the Apple licenses are affected as between themselves by variations in units. It's not just that there are changing volumes over time, but that in itself is a factor which is significant, as Lord Justice Burst noted in his paragraph 112. But particularly when you take account of the differing volumes covered by cross-licensing. This error runs through all of it. And what the judge moves to next, this is his paragraph 465 and table 9 over the page, is the detail of the ad valorem assessment. And we needn't get too deeply into this, as we will with the lump sum, but there are points to note. I point out that for this he takes Mr. Bazant's unpacking, both the free release and simple, and notably says at the end of para little 6 at the top of page 588, he's satisfied he did reliable work and was content to use the figures. And of course the related point to note is that the Court of Appeal used Mr. Bazant's simple unpacking. I hope you've picked it up, but I'm reminded to just quickly remind you that simple and free release are the two ways of dealing with the past. Simple unpacking is where you treat the whole of the units, past and future, as worth the same. Free release is where you assume the values all in the future, and so you attribute all the money to the free release. But that's what S and FR mean in those columns.
What does free release mean? Sorry.
Free release means the past release is free.
I see. That's what I see. The release of past infringements is free.
It's because the past is often called a release rather than a license.
Because you're releasing any rights you might have to complain about infringements.
It's a bit of a term of art. In these cases, everyone knows free release means everything's valued in the future.
Wow.
And the agreements are set out in Table 9 on page 587 in chronological order, identifying Mr. Bazant's ad valorem figures in column 4 for those two different versions of the unpacking. And we also see the share of the stack taken, in this case, from the earlier Table 8. Please note paras 465 little 7 on page 588. It makes a point in the last few lines as to the difference for licenses expressed as a lump sum as between simple and free released approaches. And the judge says that the simple unpacking gives an ad valorem rate that's about half of the free release. Something he expresses a view is scarcely surprising, as he says most have a 5-year term and a 5-year release period, or assuming that. And if you actually look at Table 9 and glance down through it, through the respective simple and free release numbers, I'm not going to read anything out, there are some, certainly, where the free release is about double the simple unpacking, but if you look at the licenses with counterparties with significant shares of the stack, the suggested factor of 2 is generally not the case at all. If you look at
many of them are exactly the same.
Yeah, if you look at Huawei, at the top, Ericsson position 3, InterDigital position 7, Nokia position 10, Qualcomm just below halfway down. This sentence is in fact a hangover from one of the significant mathematical errors the judge made in his draft and had to be corrected. And I'll be coming to it. But that's how that got there. The next step, para 466, is headed creating a degree of equivalence. And he considered that each individual ad valorem rate had to be comparable with each other. And what he means by this, we can see in para 466. You've got two choices: scale them all to 100% or turn each into an ad valorem rate for 1%. And I think my lords and my lady will understand that, in fact, doing either is exactly the same exercise. You're just pricing a stack either by saying what all of it costs or what a price per percent is. And so what's happening here is the licenses which are, in fact, for less than 1% of the stack have their importance inflated, and those that are for much more Qualcomm or Nokia, Ericsson or Huawei, have their importance diminished? And the key thing to grasp is the effect of this step is to give a rate that one might assume would be payable for each 1%, or however you do it, as regards consideration of each licence separately in isolation, not yet combining them. So each of the smaller stack share licences are as important as the larger this, making them all worth the same. And there are a series of rows at the foot of page 589 of the bundle which aim to draw out the differences between the total and average rates that the judge gets from the licences when he splits them into Apple and Optis. And that's to identify the difference in rates he discusses in 467 to 469 on page 590. And the judge recognises, this is para 468 and 469, that the point he'd identified as regards the Optis licence might be due to error because of the small stack size of Optis. Now that's a point which is of some significance, and initially the judge actually sought to address by an exercise to take account of this possibility by recalculating on the basis the Optis stack share might actually be, or at least understood to be, 1 or even 2%. I think I alluded to earlier that when you've got a small stack size, that can introduce a big error because it gets magnified as you multiply it up. And his aim was to show that that was not the cause of the very high AV rates compared with the Apple comparables. But he got his sums catastrophically wrong, and when it was corrected, it proved the opposite of what he was putting it forward for. So he simply deleted it from the draft. And for your note, we don't need to turn it up, but it's the exercise set out from what was para 470 of the draft on page 2306. Now, the conclusion on page 591 at para 470 is in the judgment itself. Subpara 1 and 2 is that the Optis comparables other than Google do not give useful information. And you'll appreciate we don't seek to revive those agreements on appeal, nor did we in the Court of Appeal. It's Apple who seeks to attack the converse finding, the utility of Google, which the judge deals with separately at subpara 3 on page 592. And here the judge rejects the suggestion that Apple advanced that he should dismiss this as because Google wouldn't have paid proper attention to it. The consideration was significant even to Google, and the judge notes in this paragraph that Google was able to look after itself in the negotiation. So this passage is an important passage, and the effect of the findings the judge makes here are to the effect that the Google licence is an evidentially useful comparable. And we shall see the criticisms the judge goes on to make are as to the accuracy of the ad valorem unpacking, and that's rather reflective of his general conclusion against unpacking at all. Now, the last sentence of subpara 470, little 3a, on page 592 is important. The judge says the Google licence is the one Optis comparable that suggests the Apple rates are too low. And that is an important finding as to the effect of that Google licence, and it illustrates that a licence that's too high can, when being looked at in the overall picture, still give indications as to whether others are too high or too low. And you'll be aware that Lord Justice Burst took the Google licence as indicating the same thing. Obviously, he was doing it in the context of having concluded that the Apple licences, with the proper understanding of holdout, were too low as well. But the point for you to note, my lords and my ladies, both courts below were of the view that Google suggested the Apple rates were too low.
Well, it does, providing it's a reliable comparator.
To an extent, but what I do say, my lord, is that you can look at licences which you think are likely to be too high and too low in the round as between each other, and the gap between them may still be taken as an indication that both of them are too high and too low. Of course, Of course, if you want to use it to say that a particular one that's very close is too low, then the point that you're making to me bites even more. But what I'm saying to you is that both of these courts below looked at the relative position of Google and the Apple licenses and took a view that Google indicated that they were too low. And that's not illegitimate in my submission. It may be that you don't get very much in a way of quantitative information out of it, but it's just an indication that one end of either end of what you're looking at are both too high.
Personally, I'm puzzled as to why it can mean anything except that a rate at that level or higher would not be FRAND.
I'm going to come on and deal with what they did and why in the Court of Appeal they had the extra bit about the holdout anyway. So,
But why they should lift up?
Yeah.
I understand the difficulty.
Yes.
All I'm doing at this stage is drawing attention.
Pointing out that both courts made that inference good for good or bad.
Both of them, looking at in the round, took that view. Now, the judge turns in subparagraph B to express the view as to the facts that that's the Google licence and the Apple licences, are lump sums, and he says Google could be said to be the poster child for why unpacking is dangerous, because he doesn't like unpacking at all. And subparagraph C at the foot of 592 focuses on the detail of how it had been unpacked, in particular as to the information as to the expected sales figures. And in this case, it had been unpacked from information from Mr. Blasius as to forecasts Optis prepared based upon information provided from Google, as you see elaborated in footnote 608. And you see over the page, so the top of 593, the judge does his own version of unpacking, which is pretty simple. He doesn't pay any regard to discounts that it assumes have been made for future sales units and income and net present valuing, and he just takes a flat rate. And this gives the judge an ad valorem rate, which will obviously be different to Mr. Bazant's because it's so simple. And he suggests Mr. Bazant has unpacked more aggressively, enabling a lower AV rate to be obtained. In fact, that's another muddle. The relevant Mr. Bazant unpacking is in fact higher, not lower. For your note, it's the free release figure for Google in Table 9 on page 587. In any event, subpara D on page 593, he suggests this all goes to show unpacking is a dangerous exercise. Now, just pausing here, my lords and my lady, leaving aside that muddle that I've just mentioned, with respect to the judge, what he's in substance doing here is simply pointing out that the results of unpacking will depend upon the assumptions you make as to the likely way the negotiators were thinking. So on this point, if one decides they likely didn't engage in discounts for accelerated payment or had some different assessment of sales of units, all of that kind of thing, the precise number you get out will differ. However, in fact, the experts were remarkably close in their unpacking when they made the same assumption as to the past sales value, i.e. whether they did a free release or a simple unpacking. They were remarkably close. There was not much between them at all, which Apple itself emphasised right from the offer we'll come to. But the judge is going to use this point as a reason to decide not to take account of these matters at all. Take the number of units to be covered. Of course, the precise figure one takes for any particular licence for their anticipated sales will affect the unpacking. But my submission is that's not a reason to decide not to take account of the sales covered at all. And in effect, treat every agreement in the case as the same. But that's the substance of what he does. 471 on page 593 gives his conclusion as to the AV approach for the stack, and he rejects it. In a summary of his reasons that he's gone through is the Optis comparables are useless. That obviously means the body that are AV, and the process of unpacking the lump sum licenses might be reliable is rendered unreliable by the unpacking. And of course that last point applies to the Apple comparables and the Google license. And just for your note, you'll find Lord Justice Burst summarising this section in paras 58 to 61 of his judgment. Now, the next section, section G, is headed a preference for lump sum rates. And at 472, the judge refers to his preliminary view that it's better to price the stack in monetary rather than ad valorem terms. You might have thought, as perhaps my Lord Briggs would think, that that's a sentence being said in the context of expressing DPU over ad valorem, but he's just completely forgotten about DPU. He's had in his head this thing he calls a lump sum rate. And where he's going to go is completely ignore all variation in sales volumes, the real effect of cross-licenses covering different units and the like, and he's going to use lump sum rates. Can we pick it up at 475? He's just rejected the use of unpacked Apple comparables as not truly reliable, and he says he was driven to the alternative approach of assessing price of the stack on a lump sum basis. And here he foreshadows what it's going to involve, using Apple comparables plus the Optis Google license, which was paid as a lump sum. And that does seem to be a factor. If it was paid by a lump sum, it's good in the lump sum process for a lump sum rate. This paragraph, again, is an indication that including Google is certainly not an oversight. He clearly knows that it is an Optis license. It's quite deliberately included.
Well, the other reason may be that he didn't rule it out, or he didn't rule out the Google license as he did the other ones.
Indeed.
Therefore, he's going to include that one, but not the others, which he regarded as worse than useless.
But I'm trying to answer a point that my friend made yesterday, which was to suggest that somehow he just had them in the table and didn't realise.
No, I understand. It would just be another reason for the same conclusion.
Yeah, maybe. I think you're right. Yeah. He gives actually two further reasons in 476, and this is 4761. In substance, he says using Optis licenses would be extrapolating 9 times from the same data point. So that's his kind of using evidence from the portfolio itself. Doesn't seem to be what he wants to do. But the Apple comparables concern different part of the stack. So in substance, this is completely the opposite of the use the same portfolio trance as the best place to start reasoning. He's basically saying it's better on principle to do the opposite, as I understand it here.
So by data point, he's
meaning agreement is a data point.
Yeah.
And what he's saying is 9 times from the same data point actually is the same bit of the stack. He means the Optis portfolio.
Well, yes.
But his approach is to try and reach as close to the full amount of the stack as he can. Exactly. Therefore, he doesn't want to use the same bit of information twice. That's what he's saying, I think.
Yeah, exactly. And the second reason, this is sub-para 476.2, addresses the issue of whether the price of the stack should be tailored to the implementer purchasing it. And here he refers to our submission that this was wrong and discriminatory. Of course, our submission at trial was made in the context of Apple's approach and evidence, which was a long way from what he was doing. It was an Apple special DPU. Anyway, our point is rejected. The substance of the reasoning is that whilst it's possible to defend a one-size-fits-all in the case of ad valorem rates, having the same lump sum rate payable by each different implementer is self-evidently discriminatory. And what he's doing is obviously completely odds with what the court said in Unwired Planet, to the effect that there should be a single price available for all. But of course, it's because he's adopting this really weird way of going about it. And as the judge recognises here, what was said in Unwired Planet is perfectly defensible for an AV price, which of course it was in Unwired Planet. It was an AV price. Nobody had ever thought of a lump sum rate before we got it from the judge. And he gives us an example, the implementer A selling low volumes, low ASPs, and compares that to implementer B with high volumes, high ASPs. And he says they shouldn't be paying the same. And rather tellingly, makes my point for me, 5 lines from the end. in this subparagraph. He says, consider the per unit rate that such lump sum price would have, shows a discriminatory effect. In other words, where the sales volumes were smaller, that would mean a higher per unit price. Quite so, my lords and my lady. That's why approaches in cases involve valuation on a per unit basis, whether it be ad valorem or DPU. Indeed, what every approach in the previous cases, and indeed any case I'm aware of, does that. The end of subparagraph 2 draws the conclusion that a lump sum price of the stack needs to be appropriate for the business of the implementer. This is the Apple-specific price, because he's gone to lump sums. And he goes on to say that if the stack price is prorated amongst all involved SEP owners, according to their stack share, it will be non-discriminatory.
That must mean overall stack value.
No, I think what he means is, if you do it by looking at the proportion of the stack share, it's non-discriminatory as between owners of the stack.
Yes.
Yeah, but what he's not coming up with or addressing is as between implementers. It wouldn't be.
Well, that's because he's only concerned to find an Apple relevant figure.
And the submission I make is that what Unwide Planet was concerned with is non-discrimination as between implementers. It's nothing to do with, is this non-discriminatory, is it in an Apple-specific price being shared out between owners of the stack? But that's what he appears to be thinking that's about.
Yes. But ultimately, his instinct is, for what it's worth at this point, is right, that if you're going to attribute a value to the stack, then you must apportion that between the owners of the various elements of the stack.
Sure, but in terms of Unwide Planet and what it's talking about with non-discrimination, it's just not about sharing it out fairly between owners of the stack. And what the judge is really identifying here is why working in lump sum pricing is wholly inappropriate and indeed, in my submission, nonsensical. That's what he's really identifying. And it becomes even more so where the calculations that are being done use lump sums taken from agreements with varying sales volumes and differing cross-licensing without having regard to any of it.
Well, you'll no doubt come to that in a moment.
Can we pick it up at para 480 at the top of page 496?
Because this is where we now get to the cutting edge, so to speak.
Yeah, we do. He proposes to value the stack on what the judge calls a lump sum approach. And because ad valorem is unhelpful, the lump sum approach is said to be preferred for practical reasons and reasons of principle. And again, the same mindset as to the two valuation alternatives in play being ad valorem or lump sums. DPU is absolutely nowhere. And para 481 explains that the judge views these comparables are sufficiently reliable. He doesn't say so here, but it must be the comparables that he refers to in 475, which are the Apple ones and the Google license that he says his lump sum approach involves. And the reasons in the 4 subparagraphs are, in fact, in substance, just 2. Subparagraphs 1 to 3 are directed to Apple holdout, and the judge's view that there's a distinction between legitimate and illegitimate. And I'm going to come on to that separately, so I'm going to pass over it for now. Subparagraph 4, at the foot of the page, addresses a related issue, but it's not the same. It's what one just might consider economic bargaining power. And the judge says, on the whole, Apple licenses are with big beasts and well able to look after themselves. And where he has doubts, he's going to take that into account, though he never does.
Yeah.
The Apple counterparties are in fact a wide range. On no view can it be said they're generally big beasts, and certainly not generally comparable in size to Apple. Of course, some are substantial businesses, but many are not. But even the larger ones are not comparable to Apple. One of them, ZTE, is a counterparty to both Apple and Optis licenses. And notably, as regard Optis, it's described collectively as relatively small. See, for example, 470(2) on page 591, just before the sub-para A begins. They're all being dealt with together, save for Google, and said to be relatively small counterparties. So that includes ZTE. How, in comparison with Apple, one can describe ZTE as a big beast, but in comparison with Optis as relatively small, on this side of the court we don't understand. Can we press on with what the judge calls his first cut at para 482 on page 597?
Just give me the paragraph where he talks about ZTE relative to Apple.
It deals with them collectively. So
yes,
it's 470(2) on 591.
Yeah.
And what it is words to the effect of all with the exception of Google, but you've got to know that all includes ZTE. So can we press on with what the judge calls his first cut on para 482 on 597? Here we've got table 11 introduced, and it extends over pages 598 to 603, and it includes Apple licenses that even Apple did not rely upon. At 482, you see he says he's using the licenses in the table, and he explains what the table shows, stating the last column that he calls metrics is the crucial one. And he says there are 8 metrics or measures A to H. In fact, there are just A to G. And the points to note here are the first A is a lump sum payment, and it's treated as entirely forward-looking, so there's no adjustments for the past. Metric B is the forward-looking term, and C is simply A divided by B, so it's basically a lump sum but an annual fee. And he's assuming no discount for advance payments. It's that basic. Also, the Apple stack share is included. It's the 5th measure, which he says is a constant, 1.07%. And he explains in sub 6, this matters because some of the Apple licenses provide a cross-license.
And then he sets one off against the other, as I understand.
Yeah, exactly. And he notes that the comparables provide no indication as to how the cross-license was valued, but he says it'd be irrational to say there's nothing in it, no value in it. He also points out at the end of sub-para 6 Apple was a net licensee and didn't make much of the value of the cross-license. He's right, it didn't. And that's no doubt because however large the stack share Apple enjoys compared to the counterparty, the number of sales Apple makes is vast. So the value of the value of the cross-license, although it's something that can be accounted for, it just gets lost. And there were differences in the way the experts dealt with it, but it was all agreed that the cross-licensing differences between them didn't matter. But what he does, we see the beginning of it in his metric F. He calculates a net stack share. That's the difference between the licensor and an Apple stack share.
So that would be assuming sales equivalents on each side.
Exactly. It's just yes. It's not sensible. So this is another point where just ignoring...
He puts down a warning marker at the end of Roman 7, which you're going to take us back to, presumably. He says he's going to come back to whether it's helpful.
Yes, he does. And we'll come on and see what he does there.
Yeah.
Because there's a little bit of changing what the number is. He recalculates it, assuming it's 1% when it's below, but then he goes back to the other number for most of them. But you're right, he does do something about that.
Sorry. 7 is the ethnography data, or is that wrong?
No, I think it's his net. It's his net. figure when taking off the cross-licensed.
But we start with inography and then you take off the cross-license, is that right or not?
Yeah, what you do is you get this net stack share.
Yes, by starting with the inography figure.
Yeah.
And then...
It's all inography. It's all inography.
Yes, exactly.
Yeah.
And then once you've got the stack share...
You then net it off. So what you do is you...
I understand.
And what he then does is when that number becomes very small, he starts looking for a different way of having a different number. And we'll come to it,
yeah.
But he's just laying down a marker, as my lord said.
But once you've got those two figures, for good or for bad, then you can attribute a value to that stack share. And you can work out a value of the stack.
That's what he's going to do, but whether that number's any good...
Well, I understand that.
Yeah.
But once you've got those two figures, you can work out the third.
Exactly, yes.
Yeah.
Now, finally, at the top of page 598, metric G is scaled up to a price of 100% of the stack. And he does this with gross and net. So he uses just the gross stack share without the netting off of the stack share, and he uses the net figure as well. So he got two values. And the actual calculation he does is to divide the annualised royalty payment by the percentage of the stack share. Yeah. And it's all set out over the next 5 and a bit pages, covering 20 licences.
Yeah.
And the output of the exercise is considered at 483 on page 603. And he begins with an important point. He notes there's no convergence to a single price, which he says undermines confidence in the figures. Indeed, it does. This is also another instance where we can clearly see that in the first few lines, the judge is well aware he's including an agreement where Optis is the licensor. Mm-hmm. He expressly says so. And the points he makes in the subparagraphs are, first, this is 483, little 1a. He excludes Grand Mesa, so one of the 4 licenses not relied upon Apple that he'd included now comes out, the other 3 remain in. And the next subpara B, he says the introduction of a cross-license stack raises the price and his inclination is to use that value. But he notes that sometime the netting off reduces the size of the stack so much one gets an artificially high value, and he gives an example, BlackBerry. And in subparagraph C, he addresses the issue of these small stack sizes generally, which he says is problematic. He says they're distortive because he suspects the pricing is not linear with stack share. Now, if he's right about that, he had this idea in his head that it was a bit like a taxi and that there was a flat rate of just getting in. But if he's right about that, obviously the fundamental premise that he's actually built into this, scaling up to 100% by linear scaling, is wrong. But anyway, that's his idea. And what he says he's going to do to reflect what he suggests is a fact is he's going to say there's a minimum price below which no bargain would be reached. And he says he's adopting a stack share of 1% in all cases where it's less than this. And so he reworks the licenses that he sets out in the following table, those that were small. And what happens in table 12, is a recalculation of the price of 100% of the stack for 9 agreements. He'd knocked down the 20 to 19 by excluding Grand Mesa, so it's about half of them. And the substance of what he's purporting to do is saying, I'm assuming the price reflects 1% of the stack, regardless of whether the stack is in fact smaller. And the idea is that a counterparty to Apple is able to negotiate as if they had 1%, even if they didn't. And of course, the effect of this would be to reduce the number one gets when you scale it up to 100%. So if, in fact, it was 0.5%, the factor is 2, you conclude 100% of the stack is 100 times.
So it's giving more weight to the tiny licenses.
He's doing that, but he's also reducing the price you get from them because he's assuming that instead of scaling it up...
I see.
Instead of scaling it up, say it was 0.5%, if you scale it up by a factor of 200, you assume it's 1, so you scale it up to by a factor of 100.
I see.
So that distorts, well, particularly in relation to those figures, you say that is indefensible, is that right?
It is, but then he then gets rid of most of these figures. I mean, the trouble is, he thinks that's what's happening. He gets rid of them for a reason that doesn't make sense. I'll come on and explain. And he actually only uses it for BlackBerry. It's a complete tangle, my lord. It really is. But it's an indefensible thing to have done, but then he then gets rid of it. What it's really going to is a real confusion of logic in my submission. At the foot of page 604, subpara D, we get to the issue of Qualcomm. And as the judge said, this is controversial. And this is a point where I need to show my lords and my lady what the judge had done in the draft judgment. Now, I've been trying to keep an eye on what you're doing because I want to ask you to flick to the draft judgment while we're looking at what's in the finalised judgment. I've brought along copies of a few pages that I'm going to ask you to look at. I've got a feeling all of you, apart from my lord, is looking at it on paper, so you might be able to look at the draft.
Well, I can do it because I can split my screen into two.
Okay.
So you give me the 2 page numbers. And
I will do that, but as long as you can keep them both
well,
open at the same time, that's absolutely great. And so the first thing that I want you to look at is page 2317 in the draft. And what you've got here is the table that we've just been looking at. It's actually table 13 in the draft, not table 12. And what you see, first of all, I want to just draw attention to subparagraph D, which is actually concerning Google. And this was deleted in the finalised judgment. You see what the judge said about Google at the foot of page 2317, about the sums indicated that it was an outlier, and we see his findings nonetheless as to the care with which he concludes Google would have negotiated. It's really repeating what we saw earlier, and specifically the conclusion he drew as to whether it was an evidentially significant bargain. And he drew those conclusions at a point in time where he had rather messed up his calculations as to the stack price implied by the agreement. The introductory part of the paragraph refers to the level at which he was proceeding, and you can see that in the table above. The numbers for Google are way too high. But he came to those conclusions anyway. In fact, he'd gone seriously wrong in the calculation. And of course, the evidential significance would not be lower with more modest values, quite the opposite. Let me just show you how high he calculated Google. I'm not going to read out any numbers, but if we look at what he had in table 11 of the finalised judgment, so before scaling to the agreement as covering 1%, so I'm on page 602 of the bundle, top of the page, you see the gross and net figures for his metric G.
For Google, yeah.
Google, yeah. And if you look at 215 for Google in the draft, it's about where the top hole punch would.
Sorry, what page?
2315.
2315.
Thank you.
Sorry. Yeah, I know it's difficult to compare two at the same time. 2315. You look at the numbers for Google on that page and compare them to what's in the judgment at page 602. He's out by a factor, multiplier, of somewhere between 150 and 200. Is that wrong? Those are the numbers before he's reworked it to be 1% of the stack.
That's an.
If you look
Is it the percentage of a stack that he's got wrong?
He's got that, but I think it's more than that because that would just give him a factor of 100. But you're right about that. That's one of the causes of the error is he's got the percentage wrong. But I think that would give him a factor of 100. But it's more than that. It's 150 to 200. It's about 160 something when you compare the gross and net figures in metric G. And the numbers...
I can't actually see that difference. I must be looking at the wrong thing.
Okay.
It looks not that different. It looks different, but not vastly different to me.
It's D.
I can't remember. It's difficult to explain without reaching out.
Yeah, it is.
D.
D is where he's got the stack wrong, but the numbers for the
Yes.
metric G.
Okay. Now you look at the figure here.
Metric G is huge.
Yeah.
Yeah. Is that because of the percentage?
Oh, I see. And then that figure. Yes, I see. Yes.
The percentage of the
Oh, I
stack.
thought that was. I was thinking of that as a point, but it's a comma. Yeah.
Yeah.
The percentage of the
What I
stack
thought was
is.
yeah. All right. I see now.
Yeah. The percentage of the stack, my lady, is definitely contributing a factor of 100.
Yes.
Yeah.
So it's not the whole of it.
No.
Yeah, it would have been a lot of money even for Google.
And he got the reworked covering 1% completely wrong. So if you look at the entry on table 12 in page 604 of the judgment, with the numbers in table 13 of the draft on 2317. So looking at Google there, he's a factor of 10 out. .604, my lady, third from the bottom of page 604.
Oh, yes, sorry. Thank you.
Moves around in the table,
Yeah.
but then, actually, it's the same place in the draft. 2317, it's a factor of 10. And that's no doubt why he deleted what was para D in the draft, because Google became not an outlier. They were just catastrophically wrong calculations. As for Qualcomm itself, he got a complete muddle on those figures. Can I point out the discrepancy in the final judgment, table 11? We need page 601. So the metric G figures, 601, they're towards the middle of that page. And my lords and my ladies, see the total consideration in box A also there is made up of those components. And in the draft judgment, we need 2314 towards the foot of the page. And he's just got the consideration at A wrong. He's used the numbers there. They're massively wrong, and his box G numbers towards the bottom of page 2314 are also way out.
Just went up from the bottom of the page.
The judge wasn't asked how these figures came to be wrong, but they were pointed out. He corrected them. He stood by certain conclusions and he took others out. So what do we derive from these details?
Well, they're an illustration of why he should not have been doing his own method.
Well, I understand that.
But also, it comes on to what he did with Google, with Qualcomm. It's
Right.
to do with what he did with Qualcomm. It's the statistician blush point.
Thank you. Okay.
Before we leave the point, just for your note, I won't run through them, but he got other numbers wrong too. Ericsson, Huawei, CCE. It's a complete tangle. Now, Qualcomm at the foot of page 604, over to the top of 605, and the exercise he does in table 13 is what I need to describe next.
Are we leaving the drafts?
We are for a bit, yes. Yep. I have to come back to it on the past future, but that's a separate point. And his reasoning at subpara D at the foot of page 604 state, oh, actually, I think I might have promised you too early. Sorry, I think we might be going back to it.
That's the final, and the draft was
Around 23118.
just off the bottom of the table, isn't it?
But for the moment, you want us to look at page 604.
604. And that reasoning at the bottom of 604...
It's 2318, it's E in 2318.
Yeah, yeah. And it's the same in the draft. And it's the fact that Apple contended Qualcomm should be excluded, and it gave a high number. Optis contended it should be.
You say that comment on Qualcomm only makes sense in relation to the draft and not the final.
Well, it's the same in both judgments. We were both arguing for that. Neither of us knew what numbers he'd come up with when we were arguing for that because he hadn't done it. In the judgment itself, we get to the introduction of Table 13 on 605, and just concentrating on that just for a little bit, although keeping 2318 open, you've got 483(2) on 605. What the judge done here is taken the licenses he's using and arranged them in descending order.
Yeah.
That's his AV1 column. So BlackBerry through to Pantech, and he's excluded Graham Messer. Google's position is at place 16 out of 19. But if you've still got the draft open, you can see where he thought Google was in the draft. Position right at the top on page 2318.
Yes.
It's table 14 there. And Qualcomm's third on the list. And in the finalised judgment, 43483, page 605, he explains his AV2 column is to reflect the adjustment to assume 1% stack share, so that idea that we've just been talking about. And he says in subpara B, in some cases they make obvious sense. Strangely, he goes on to say, no doubt because these adjustments were already made in negotiations, he considered the adjusted rates to be inappropriate in most cases. You would have thought if they had made the adjustment to 1%, then he should be using the numbers, but he gives the reason of the adjustment being made in negotiations as a reason not to use them. And in fact, what he does do, as you see there, the highlighted ones, is he only uses BlackBerry. And the change, what we've got, the funny some cases, plural, when in fact it's just one, is because previously it had been two. I'm not going to take my lords and my lady through that, but it had been two. He was going to do it for Google and BlackBerry in the draft. And what he's doing here is identifying different ways of dealing with the series of figures. The first one, going to AV2, is to adopt those adjustments to 1%. And AV3 is where he picks and chooses between those two. And you've also got AV4 and 5, where what he's doing is taking the top 3 or 5 and the bottom 3 or 5 out. Depending upon whether he thinks that too many of them are outliers. Now, what actually happened is that previously Qualcomm had been included, but in the actual judgment you see a whole load of new text that have been inserted. Subparagraphs A to D over page 607 are all new. They were not in the original draft, save for the introductory words stating he thought long and hard about it. And it's a major change from what he did in the draft, where he included it. And what he does is basically take the average from column 1 as the Qualcomm evidence, or the number for Qualcomm. So instead of using a value from Qualcomm, he replaces in his AV3 column a number which is in fact the average from column 1, which in my submission is simply no better than identifying a random number roughly in the region that you might think that the number that you want is. he takes a number that is the average of all of the values in column 1 and says, I'm going to use that in my column 3. So the net effect is that he prefers column 3, which is itself an average, but the number that he purports to put in there as Qualcomm in the nuanced way has got nothing to do with Qualcomm at all. It is in effect, Qualcomm's been averaged through it twice. Through the washing machine of averaging has been used twice for Qualcomm to give it no effect. But that's what he does. He's purporting to include Qualcomm, but the number that he uses has nothing to do with Qualcomm at all. Now,
That's little C on page 607.
I beg your pardon?
That little C on on page 607.
Yes. Yeah. Little 8 at the bottom where he says the statistician would blush. That's what he's done. He's talking about there.
Yeah.
Yeah. Now, I think I'm going to try and deal with what he does on the past future without taking you through every single page. And I'll tell you what he does, because I'm conscious of the time.
Just before you, can I just ask you one question? The changes to the figures that one can trace from the draft through to the final followed that great long document that the parties put in based on the draft, presumably.
Yeah. Yes.
But without spending the best part of a weekend with a coal tower on one's head, it would be hard to know the extent to which the changes represent agreed comments or his judicial choice of different comments.
I actually think that in terms of the numbers, I'll be corrected if I'm wrong, and I will correct myself tomorrow. I think the numbers, we knew what he was doing, and I think all the numbers were agreed.
So once you understood his method,
yeah,
you're not complaining about the final version of the figures.
No.
Right, that's what I wanted to try.
Yeah, absolutely. I don't think that. I don't think there was any
Qualcomm.
dispute between us.
Say for Qualcomm.
Well, yes.
Well, you're complaining about the figures he used, but not about the arithmetical calculation.
Exactly.
Yeah.
I think that was the question.
Yeah.
Now, on past future, what the judge did was he initially in the draft looked at the simple free release numbers in that table that I showed you earlier, where you had, do you remember that statement where he said they were roughly half of the other? And that was there because the numbers before they were corrected were roughly half the other. In fact, the averages were, he took them from the bottom. But when it was corrected, it was nowhere near 50-50. So he'd previously given as a reason for slashing the number in half, saying the price for the past is roughly the same. I can see it in the numbers. It in fact is. Instead of doing that, what he then did is change to the judgment that you see 485, where he refers to what the actual split is in the numbers when corrected. I'm not going to read them out, but he says it's nowhere near 50-50. And so he says, well, I'm not going to do that because now that's evidentially dubious. And he decides to split it 50-50 anyway because he says it should be. They ought to be priced the same. And what he's doing there is getting in a muddle between what might be FRAND and what in fact did happen in negotiations. So this is another area where what he's done, when we come to it, in effect you've got anchoring. He's decided what he wants to do. When his reasons don't fit it, he looks around for another reason. And the new reason is unsound because at this stage in the analysis, what you're trying to do is work out what in fact had happened, not what should be FRAND. So that's me taking that a little bit quickly. But what you end up with, my lords and my lady, is the value of the entire stack for an annual fee is para 486 on page 608. £1.35 billion. And just to give us a sense check for that, 1.35 billion per year for the whole stack, that's 100%. Compare that to what Apple paid Ericsson for 4.15% of the stack, so about 1/25th of the whole stack. I'm not going to read out numbers, but you can see in table 11 on page 598, at the bottom of the page, this is for a period of 7 years, so you've got to bear that in mind, but you can see what was paid in box A for about 1/25th of the stack.
5 billion.
No, you don't. It's confidential.
Oh, I'm so sorry.
So that's the 1/25th of the stack.
Yeah.
And then the other figure you asked us to look at was a moment ago?
Just for 7 years, I'm comparing that 1.35 billion for the whole stack. I'm just asking my lords and my ladies to compare that to the price for Ericsson for 1/25th of the stack. But you've got to bear in mind that was for 7 years.
Yeah.
So,
So the annualised payment do we look at or not?
Yes.
For Ericsson to compare?
I can't read it out. I
know,
But
but
is that-
it has a royalty payment, then a term 7 years, and then an annualised payment figure. Is that the one we used to compare?
Yeah, exactly.
Multiply that by 25.
Yeah. And that's the point I was trying to make rather clumsily, is to make sure that you appreciate that it's a 7-year thing, so I can't. So exactly. So the annualised figure you would look at and multiply by 25 to get a bit of a thing. But you also have to bear in mind that this is, certainly on the Court of Appeals analysis, a holdout licence anyway. Now, we have summarised the key errors in the judgment in our printed case over paragraphs 74 to 81 on pages 124 to 125, which we built upon in paras 82 to 89 to explain why no part of it can be salvaged. And my friend yesterday recognised the nature of what he called our 4 respondents' notice points, not as points going to support the Court of Appeals order as such, but further reasons that the judge's decision couldn't stand. They were points run in the Court of Appeal but did not in the end need to be formally decided. My friend claimed we had not covered them in our case, but that's not right. They're covered in that section that I've just identified, 74 to 81, as part and parcel of all the errors the judge made, and we specifically identify them by the ground number in the Court of Appeal, also saying where they're not resolved in the Court of Appeal, and we specifically said that we were maintaining them at the end of paragraph 74 of our printed case. And just very quickly for your note, that listed in the respondent's notice at point 1 is paragraph 77 of our case. It's identified as Court of Appeal ground 5 not resolved. Paragraph 78 of our case is the second point in the respondent's notice. It's the Qualcomm licence issue. And the third point is paragraph 80, the past-future treatment. And the fourth respondent's notice point is the ground 25 issue, which is the mental anchoring from the draft judgment. And that arises on 2 of those previous paragraphs as we identify. So the Qualcomm and the past-future issues. So paragraph 78, we refer to that aspect of it right at the end. And at paragraph 80, you see a reference to the initial rationale in the draft just about halfway through. So we have identified them, we are relying upon them, but my friend's right that they're reasons that the judge cannot stand and nothing can be salvaged. They're not reasons as such that the Court of Appeals order should be upheld. Now, this section of our case covers only the major points, so it's not all the individual instances where it's apparent the judge hadn't really understood the effect of it. And they're only the serious errors, but they're errors of substance and procedure. The rejection of all the expert evidence and presenting a new unforeshadowed method as part of the substance of what we have in numbered error 3 on page 124. The judge also fundamentally misunderstood the relationship between the valuation exercise in per unit rates of one kind or another and lump sum payments, didn't understand the basics of the parties' cases. This is error 4 that we identify. This also fed back into the unfair criticism of the experts, for instance, Mr. Bazant for not unpacking AV to lump sum. He embarked upon a novel lump sum annual fee approach that embodied several errors over and above the fact that it was entirely new and developed without reference to the parties or the experts. Those errors included not taking account in variation of sales volumes, variation in Apple figures themselves were significant, as I think I've already drawn attention, Lord Justice Burst says so in 112, but also the grossly inaccurate approach to cross-licensing. The decision also embodied the error of rejecting the cimetidine approach, including a wide range of agreements when they're obviously not all as good evidentially. And those are the two errors that we've identified at error 1 and 5 respectively. Now, my friend seeks to say that he was not taking a cimetidine approach. That's a surprise, and certainly the judge understood they were. For your note, it's the section of the judge at page 503, para 290. That's something the judge and the Court of Appeal agreed on, and they were right. And I think the way my friend tries to deal with it is by pointing to other aspects of his case that he was running. Of course he was running other aspects, including an alternative limb of top-down as to calculating the overall stack price, which we also engaged with, because he distorted it by missing out some licences. But that, in my submission, is not to the point. Of course, both sides had other cases. My point is both sides were running a conventional comparables case. We've identified references in paragraph 70 of our case where both sides are accepting that if there were non-FRAND behaviour, that would make a licence less reflective of what a willing licensor or licensee would agree. And in 68 and 69, both sides angling for different comparables being considered to be more or better comparables than closer ones. All consistent with both sides running a case and being engaged in looking at comparables to identify the both. Back to the errors, my lords and my lady. Just to round them off, the inclusive averaging or anti-cimetidine approach was in itself an error. That's number 9 in our printed case. And it also included using licences that both parties had rejected and led him to take a completely unjustified approach to how he purported to include Qualcomm. We addressed that at para 78 and again 87, it's error 7. And Qualcomm is just one instance of this anchoring. The other is the past future that I've already identified. That's error 8. Another error is the non-FRAND behaviour, which I'm going to come on to. That's error 10. And the way he dealt with past and future, as I've already foreshadowed. My lords and my lady, there is absolutely nothing sound that one can extract from this methodology in my submission. And you certainly can't look at any particular decision or level of generality which is not tainted by these errors and decide that this can be kept. And I also ask, what about the procedural error, the procedural unfairness of springing it on the parties without reference to the experts or them? My friends just don't grapple with that because there's no answer to it. It's 4 o'clock, I've come to the end. It's been a really hard slog.
Not only for counsel.
Yes. It's necessary, though, to understand just what a tangle the judge...
Oh, we understand that. I'm just joking. I mean, we're very grateful, as indeed we were to Mr. Turner, for the clarity and succinctness of the presentation we're receiving. Very well. We'll adjourn then, and tomorrow we're resuming at 11 o'clock.